WorkSafe is a division under the Department of Attorney General and Justice and have multiple roles in the administration of various pieces of legislation, including the Return to Work Act for workers' rehabilitation and compensation, which I'm here to talk to you about today. The Northern Territory has been relatively fortunate with the coronavirus, with 32 confirmed cases, with all people affected making a full recovery and having no community transfer. However, there are still Territory businesses who are affected by COVID-19, and given the uncertainty of this virus, it is not a time to become complacent. We're hoping that today's presentation will provide you with knowledge and understanding on how to support injured workers and to ensure obligations are met. For those watching online, I ask that you mute your microphones and turn off your cameras. There will be time allocated for Q&As at the end of the presentation. During the presentation, if you do have any questions, you can select the chat icon that looks like a notepad. This will bring up a sidebar where you can add your questions that will be answered during the Q&A. The Return to Work Act defines an injury in relation to a worker as a physical or mental injury arising out of or in the course of employment and includes a disease. A virus like COVID-19 is likely to be considered under the disease provisions of the Act. For a disease to be covered, it must arise out of or in the course of a worker's employment. WorkSafe does not make the liability decisions on claims. This is done by the approved insurers and self-insurers, as the Northern Territory is a privately underwritten scheme. For liability to be accepted, an insurer would need to be satisfied that the employment was the real, proximate or effective cause of the worker contracting the virus. For viruses, it can be difficult to accurately determine the exact time and place of contraction. As a result, it may be difficult to determine the employment was the real, proximate or effective cause of the worker contracting the virus. However, where a worker's employment puts them at greater risk of contracting the virus, the significant contribution test may be easier to meet. For example, if the employment involves travelling to an area with a known viral outbreak, or activities that include engagement or interaction with people who have contracted the virus, such as health workers. Each claim would need to be considered on its individual merits, taking into account the individual circumstances and evidence at the time the decision of liability is to be made by the insurer. In the early stages of an outbreak, where there are limited numbers of known infections, there is potential to track exposure. However, as the virus becomes more prevalent within communities, such as the outbreak in Melbourne, it will be difficult to identify where a person was exposed to the virus and that it occurred out of or in the course of a worker's employment, as with the common flu. Please note that self-isolation does not mean a person is suffering from an injury or a disease. So what is the insurer's stance on accepting liability? So when deciding whether to accept a workers' compensation claim, which includes the claim relating to the diagnosis of COVID, insurers will apply specific criteria from the Return to Work Act. So the criteria will include, but is not limited to, the following. The claim was made within the required time frames. So under the Act, it states a worker is to lodge a workers' compensation claim within 6 months after the occurrence of the injury, or in the case of a disease, the incapacity arising from that disease. Another criteria, so the worker was in fact a worker. An injury or disease, so diagnosis of COVID, has occurred. The exposure to COVID occurred in the work environment. That the worker's employment was a real, proximate, effective cause of the worker contracting the virus. Insurers will rely on information from you as the employer, your worker, and the medical practitioner when using the criteria to determine whether the claim will be accepted. Please note that provisions exist under the Act to enable a worker to appeal a claim decision made by the insurer. This is the disputes resolution section of the Act that covers internal review by the insurer on a decision and the mediation process. For further information about how your insurer will decide on the liability of claims, we recommend you contact them directly to discuss further. As stated previously, all claims are determined on their claims merits. It should be noted that management action taken on reasonable grounds and in a reasonable manner by or behalf of a worker's employer is not considered to be a mental injury for the purposes of the Act. Management action interpreted under the Return to Work Act in relation to a worker means any action taken by the employer in the management of the worker's employment or behaviour at the workplace. The Act outlines the scenarios of management actions. Some examples that we might see under management action that relates to COVID could possibly be requesting all or some staff to work from home, relocating staff around the office or in different office locations, ensuring the 1.5 metre social distancing measures are in place, conducting meetings through online portals, requesting staff stay at home if feeling unwell with flu-like symptoms. Employers following mandated instructions as directed by the Chief Health Officer by the way of their COVID-19 safety plan checklist could be viewed as reasonable management action if a claim was to be lodged under the circumstances I just mentioned. This is based case by case, with the insurer taking into consideration all relevant information provided to them at the time a decision is made. So how do I return my injured worker to work? So returning an injured worker to work is a dedicated process that requires the employer and the worker to have a clear understanding on what the return to work goal is, and taking into consideration the worker's medical restrictions and capacity to undertake the duties. COVID-19 may make the return to work process just that little more challenging if a business is closed or is operating at partial capacity. However, regardless of the impacts of COVID, an employer's obligation remains, and that is to assist an injured worker to return to work. It is also important for employers to be mindful and try to minimise feelings of uncertainty for these workers, as COVID-19 has created another level of anxiety for those workers who have been injured. When a worker who has been fully incapacitated for work is then certified to return to work in some form of capacity, the employer is obligated to assist the worker with suitable duties in the workplace. If the suitable duties are not available, such in the case that COVID has forced a business to operate at reduced capacity or unable to reopen with staff, then the employer must assist the worker with the support of the insurer to find suitable alternative work. Alternative work can be in the form of modified duties, a new position within the business, or work with a different employer altogether. To support this process, a vocational rehabilitation provider may be involved to assist in sourcing alternative employment with a new employer, or review the workplace to ascertain if the worker could undertake any alternative duties with the same employer, as this is always the best case for both the worker and the employer. During the interim, when work is being arranged for alternative work, the worker is to be paid at their workers' compensation rate of pay. This includes the host employment activities the worker undertakes with a different employer. This arrangement is a short-term arrangement that assists the worker to increase capacity until they are fit to return to their normal workplace or their normal duties. Everyone involved with a worker's return to work, so the doctor, the worker, the employer, the vocational rehabilitation provider, and the insurer's case manager, should communicate and work together to achieve a successful outcome. Studies have shown that staying at or returning to work is an important part of a worker's recovery. WorkSafe has developed a number of videos to support workers, employers, and other stakeholders in workers' compensation. We will now show a short video to assist employers in the return to work process for injured workers.
Welcome to the Northern Territory Workers' Compensation Scheme. This short video will assist you getting your injured worker back to work. We'll explain what to do and what help is available. Our presentation, Making a Claim, explains the claims process for workers following an injury at work. Staying at or returning to work is an important part of a worker's recovery. The longer an injured worker is away from work, the less likely they will ever return. Injured workers have, as part of their claim, access to services and support to help them return to work. Employers have control over the workplace, workforce and work duties, and are expected to take a lead role in working out how, when, where, and in what way a worker will return to work. Everyone involved with a worker's return to work activities, the doctor, the worker, the employer, the vocational rehabilitation provider, and the insurer's case manager should communicate and work together to achieve a successful outcome. If the nature of your worker's injury is likely to keep them away from the workplace, remember to stay in touch. Talk to them regularly. Invite them to staff meetings. Invite them to training. Invite them to work social events. Encourage them to contact you if they have any concerns. If you become aware that your worker's total or partial incapacity is likely to exceed 28 days, then you must give a proposal in writing to your worker for a return to work plan. Also, ask your worker to provide a fitness for work medical certificate. These describe what work they are able to do. There are 3 steps in the return to work process. As soon as you receive a fitness for work medical certificate, you and your worker can start to plan their return to work. Discuss suitable duties you've identified with your worker, keeping in mind their medical restrictions. Also consider the worker's usual job, education, skills and experience. What alternative tasks they can perform. Their working hours, what supervision or support they may need, and any workplace modifications and equipment needed to help them work safely. It's important that the return to work goal is identified early so everyone can work towards it. This will be documented in the return to work plan. Most workers are able to return to their usual job. However, if the injury is severe, a worker may be away from their pre-injury position for weeks, months, or may never be able to return to that job. If this is the case, consider if you can provide them with modified duties or a new job permanently. Alternatively, they may need help finding a new job with a new employer. A vocational rehabilitation provider can help identify suitable duties, arrange a work trial or retraining, or assist if there are other issues affecting the worker's return to work. Speak to your insurer if you need assistance in developing the return to work plan, appointing a vocational rehabilitation provider, retraining or finding a new job with a new employer. The final step is to prepare your workplace for your worker's return. Make sure the return to work plan documents the suitable duties, hours of work and restrictions, and that it's signed by you and your worker. As an employer, you should ensure that your worker is not made to feel uncomfortable when they return to work. Co-workers do not always understand the return to work process and are unsure what to say or how to behave. Talk to your workers about your return to work program for managing workers who have suffered a work-related injury. Take care not to divulge personal information about an injured worker. Monitor and review the return to work plan at regular intervals and on receipt of progress certificates. The injured worker is expected to take an active role in their return to work. If problems arise or your worker unreasonably refuses to participate in their program, talk to your insurer. They may also request a case conference to meet with everyone involved in the claim and talk through the issues. Watch our case conferences video to find out more. Further information and help are available. If you have any questions, contact the claims manager or NT WorkSafe, who can assist you.
How can my injured worker get medical treatment? So the Act requires a worker to undertake reasonable treatment and training or assessment. However, insurers and self-insurers have strong contingency plans in place that include making alternate arrangements to assist injured workers and taking reasonable and proportionate action in these challenging circumstances. In the Northern Territory, most medical and allied health providers are now treating injured workers face-to-face. This includes surgical procedures. However, there are some treatments and surgical requirements that are not conducted in the Northern Territory, therefore requiring a worker to travel interstate. Many of these medical interventions have been placed on hold due to border closures, requirements to mandatory quarantine, or the high risk of exposure to the virus, which creates additional apprehension and stress not just on the worker, but their families and workplaces. In the case of NT workers who have relocated interstate and are in a heavily restricted area, their treatment requirements have been placed on hold, with only interaction being through the telehealth platform or the like. Again, this places additional stresses on the worker and can potentially have an adverse effect on their mental health and their recovery. As insurers remain in operation, it is crucial for claims managers to be mindful of these circumstances, ensuring the worker is being supported in the right way for that person. In regards to post-operative reviews that would normally require a worker to travel interstate, many specialists have been using telehealth to assist in conducting these types of reviews, with the assistance of qualified allied health professionals such as physiotherapists. For independent medical assessments known as an IME, a majority of the consulting specialists are fly-in. Due to the height of COVID in the NT, many of these specialists were using the telehealth services to conduct their assessments in the same form for the post-operative reviews. Again, the allied health professionals were required to conduct the physical aspect of the assessment for workers with physical injuries. As the restrictions have eased in the NT and the opening of the borders, there's been an increase of specialists now flying back to conduct their assessments in person for us in the Territory. The COVID pandemic has shown the medical profession, like many others, that there are other ways to conduct business, which has ensured injured workers continue to have access to their treatment providers and that the negative impact on recovery has been reduced. NT WorkSafe developed a number of frequently asked questions that aims to help employers with general questions around COVID for workers' compensation. These are located on the NT WorkSafe website under the Workers' Compensation tab. So some of the more common questions that we were asked have been, does my workers' compensation insurer cover my workers' wage during their self-isolation period? So the answer to this, your insurer will not cover wages for your worker during self-isolation unless there is an accepted claim. If a worker lodges a claim for COVID, the insurer will require a completed workers' compensation claim form, a current medical certificate of capacity. This is issued by a medical practitioner that provides the assessment and the diagnosis. Evidence to demonstrate that the worker's COVID exposure occurred within their work environment and that the employment materially contributed to the worker contracting the virus. So for liability to be accepted, the insurer would need to be satisfied that the employment was the real, proximate or effective cause of the worker contracting the virus. So another common question, what impact will these claims have on my premium and will I need to pay an excess? Workers with accepted claims for COVID will have access to the same compensation entitlements that are provided under the Act for other compensable injuries or diseases, such as your weekly compensation, medical and rehabilitation expenses, and return to work support. As NT WorkSafe do not regulate the premiums for insurers in the Northern Territory or manage the workers' compensation claims, we highly recommend that you discuss any concerns you do have with your insurer. Another question that we've been asked, so what are insurers' plans for maintaining workers' compensation activities? So all insurers have provided NT WorkSafe with their business continuity plans detailing the processes and systems in place in relation to their workers' compensation insurance activities. The plans outline that workers' compensation services will be maintained and any impact to you as a policyholder resulting from the coronavirus pandemic is minimised. If you do have any questions or specific questions or concerns relating to your policy or your workers' compensation claims, please contact your insurer and they'll be able to provide further clarification to this. So the government JobKeeper payment scheme provided many questions around workers' compensation, especially for workers already receiving weekly compensation. So again, to assist, we developed some frequently asked questions around the JobKeeper for workers' compensation. Again, these are based on our website. So we note that there have been recent changes to JobKeeper scheme also. However, the amounts that I've mentioned in my following examples are purely just examples for the scenarios. So some of the common questions that we've been asked. Due to COVID-19, I have had to stand workers down. They are not performing any work at my business or working for the business from home. If I receive JobKeeper payments for my workers, will I have to declare the $1,500 payment in my wage declaration? In this scenario, the worker is not performing work or service for the employer and would therefore not meet the definition of a worker under the Act. The Act defines a worker as an individual who performs work or service of any kind for an employer under a contract, and in relation to that contract is an employee for the purpose of assessment for PAYG withholding under the Taxation Administration Act, even if the employee is not withholding tax when they should be. As these workers would not meet the definition of worker pursuant to the Act, they would not be entitled to lodge a workers' compensation claim. The JobKeeper payments allow the business to maintain an employment relationship which will enable a fast return to work when restrictions relating to COVID are lifted. In this scenario, the JobKeeper payments would not be treated as wages for the purposes of the Act. Another question, an injured worker has an accepted claim and is totally incapacitated for work. What is the impact of the JobKeeper payment? According to the ATO, employees currently on workers' compensation where they are totally incapacitated for work would not meet the eligibility requirements for JobKeeper payments. The JobKeeper payments program does not override or alleviate worker entitlements or employer obligations under the Return to Work Act. Employers and insurers must continue to pay all workers' entitlements. You will find further questions on JobKeeper on the WorkSafe website under the Workers' Compensation tab just mentioned before. An injured worker has an accepted claim and has returned to work with restricted hours, days and duties. However, the worker's normal weekly earnings are less than $1,500 per fortnight. What is the impact of the JobKeeper payments? So if an injured worker passes the eligibility test provided to the ATO, then as an employer, you may be able to receive JobKeeper payments for your injured worker. If your injured worker was normally paid equal to or less than the $1,500 per fortnight, then in accordance with the ATO rules, the employer must pay the worker the full amount. As the worker is receiving an amount below or equal to their normal weekly earnings from the JobKeeper payment and the employer has no out-of-pocket expense, the employer cannot request the insurer to reimburse that $1,500 paid to the worker. The JobKeeper payment is a wage subsidy, not an expense for the employer to include in the sum for which they are liable. Care should be taken to ensure that the employer is not seen to be double dipping. Working from home. So if you've instructed your employee to work from home and they meet the definition of a worker and are injured while working from home, a worker may be entitled to claim for workers' compensation. Whilst a worker is not attending their normal business premises, the home of a worker will be considered a workplace under the Return to Work Act. So what is considered a workplace injury at home? A workplace injury is any injury that a worker sustains out of or in the course of employment, such as, but is not limited to, the following: a repetitive strain injury or other musculoskeletal injuries. So this may be caused for many reasons, such as an incorrect workstation setup, not taking breaks, or working longer hours without breaks. Psychological injuries, such as anxiety and depression. So this may be caused for many reasons, such as an unsupported working arrangement, incorrect resourcing, or the isolation of having limited or no contact with peers and supervisors. The unfortunate aspect of over 2.5 million Australians working full-time from home is that many will experience mental health consequences that they may not have been at risk if COVID had not occurred. Some other injuries that may occur could be injuries whilst on a recess break, such as burns from making a coffee, or simply tripping over Lego blocks on the floor and injuring their arms. Employers still have a responsibility to ensure a worker has an ergonomic work desk and chair, and the hazards and risks around the workstation are minimised, such as the lighting. In order to minimise the risk of sustaining a physical injury, employers, prior to directing a worker to work from home, should have assessed the suitability of the workstation environment in person, or given the scenario of COVID, via video call, conducted a risk assessment, or provide the worker with a workstation self-assessment checklist. When it comes to a worker's mental health when working from home, employers are required to provide clear instructions to workers on how to perform duties in a safe manner with regards to their own mental health. Understanding how to report any issues being experienced with mental health, and provide workers with access to communicate with colleagues and bosses through video calling and other messaging platforms. If a worker sustains an injury working from home, they can lodge a workers' compensation claim with their employer, who will then provide to their insurer within 3 working days. The insurer will make a determination on liability with the information they are provided at the time the decision is due. The NT has been extremely fortunate with the limited effects that COVID-19 has created compared to the cities like Melbourne and Sydney. Many businesses have returned to business as usual, or the new normal, as directed by the Chief Health Officer through the COVID-19 safety plan checklists. For many businesses, especially smaller businesses, many closed their doors and cancelled their workers' compensation policies. However, with the lifting of restrictions in June, many businesses commenced reopening and having staff return. It is now a timely reminder that if workers' compensation policies were cancelled as the business closed due to COVID, and the businesses have since reopened and employing staff, a workers' compensation insurance policy must be obtained prior to those staff returning or employing. It is compulsory for employers in the Northern Territory to hold a current workers' compensation insurance policy to protect both the worker and the employer if a worker is injured in the workplace. It prevents an employer becoming insolvent as a result of higher claim costs, and prevents a worker being financially and medically disadvantaged due to their injury. Working together, the impact of a work-related injury can be minimised and help workers return to work safely, permanently, and at the right time. Employers' mandatory workers' compensation insurance is an expense for employers and cannot be passed on as a charge to workers. Employers must not make charge or levy on workers for the cost of the employer's workers' compensation insurance. The cost of the premium is considered one of the costs of doing business. For further information on the requirements of workers' compensation insurance, please refer to the NT WorkSafe website under the Workers' Compensation tab, where you will find a number of bulletins and guides. As at the end of September 2020, the Northern Territory has had 5 COVID-19 related claims. 4 of these claims relate to the psychological impacts of COVID-19, and 1 relates to a physical injury that was sustained whilst working from home as a result of COVID-19. The effects of COVID on workers varies from additional stresses due to working from home, working longer hours, and without the right supports in place. This also includes inappropriate home office setups causing the RSI type injuries. During Safe Work Month, eReports, a medico-legal company, provided a presentation on mental health and the effects of COVID-19 working from home. And IPAR, a vocational rehabilitation company, provided a presentation on the ergonomics around the home and the office setups. So you're more than welcome, once they're up on our website, to have a look at those. So what is covered under a COVID-19 claim? So having an accepted claim for COVID-19 does not alter a worker's entitlements under the Act from any other accepted claim for an injury or a disease. Entitlements for workers with an accepted workers' compensation claim under the Act include weekly compensation for loss of wages. Workers are entitled to receive their normal weekly earnings for the first 26 weeks of total or partial incapacity, less any amount that they actually earn. If after the first 26 weeks workers are still incapacitated, they will normally be paid at 75% of their loss of earning capacity. There are minimum and maximum provisions that apply also. So other workers' compensation entitlements that they may be eligible for include reasonable cost for medical, surgical, rehabilitation treatment, hospitalisation and hospital treatment, pharmaceutical expenses, travel or transportation costs to attend treatment or hospitalisation. This includes the kilometre allowance for using their own vehicle, upskilling or training for a different career if the injury prohibits working in a pre-injury position, and payment for a permanent impairment. The above list is not exhaustive as the needs of individual workers are different. A question anti-WorkSafe has been asked that specifically relates to self-isolation is, if a worker cannot self-isolate at home and is consequently required to go to another external location, can they claim expenses incurred as a result of the relocation? The answer, if your worker has an accepted claim for their work-related COVID-19, the insurer will cover reasonable costs if there is a requirement confirmed by a medical practitioner for self-isolation outside of the worker's home. Another question around the costs of COVID is, I've independently arranged for my workers to undergo testing for COVID. Will my insurer reimburse me these costs? An insurer will only reimburse these costs if your worker is subsequently diagnosed with COVID and that the exposure is confirmed to be a work-related injury, or your worker has an accepted workers' compensation claim. Under the work health safety laws, employers must have measures in place to eliminate or manage the risks arising from COVID-19. To ensure all Australian workplaces receive the most up-to-date information, Safe Work Australia has published information on managing the risks from COVID-19 in the workplace and on their website. You will also find information for the Northern Territory on the anti-government coronavirus website. Some suggested physical distancing in your workplace could be addressed by the basket barrier that you can see here on the slide. So this would definitely be keeping you and your workers safe at a distance, or perhaps not. So refer back to the Safe Work Australia's website for appropriate information that suits your business requirements. Anti-WorkSafe are working closely with other departments such as health and councils to ensure knowledge is out there for both employers and injured workers on entitlements and obligations throughout the Territory. Anti-WorkSafe will continue to strive to promote and educate all stakeholders involved in the scheme. I would like to thank you all for attending today's presentation, and if you do have any questions, please feel free to use the chat icon that I mentioned, the little notebook. However, if you don't think of any questions now, but you do think of some questions later on, please feel free to email us or phone us, and our details are on our website. So thank you.